Oh, thank you, thank you. Good afternoon, everyone.
After lunch,
Good afternoon. Can we please have our seats so that we can start? Thank you for taking your seats. Good afternoon, members, again. I hope you had a good lunch. My name is Millie Odhiambo-Mabona, Member of Parliament from Kenya, and also a member of the board of the PGA. Sorry that we have started a little late, and we hope to catch up with time in the process. And our panel, which is a second panel for this session, is on regional perspectives on the Rome Statute implementation, understanding the variances in the adoption of the reforming national laws. I know in the morning we had a lot of discussions around countries and the status of implementation of the Rome Statute in those countries. We're going to hear a little bit more from other countries on the implementation of the Rome Statute. And to start us off, we have Deputy Ramón Barrios from Honduras. I hope I got it right. Bienvenida. Proceed. Just to alert us, because he's going to speak in Espanol, you can switch on to channel 3. The English channel will be channel 3. Thank you.
You need better?
Buenas tardes, muchas gracias. Permítanme hablar en español por la fuerza de las palabras y de los sentimientos que tiene el idioma, en que voy a decir un sentimiento compartido quizá por ser el único representante de los parlamentos de Centroamérica. Honduras, mi país, firmó el Estatuto de Roma el 7 de octubre de 1998 y lo ratificó el 1 de julio del año 2002, una vez que lo aprobara el Congreso Nacional por unanimidad el 30 de mayo de ese mismo año. El 24 de enero del año 2002, la Corte Suprema de Justicia de mi país dictaminó a favor de la ratificación del Estatuto de Roma y estableciendo lo siguiente, la Corte Suprema de mi país: quien viola los derechos humanos ofende la conciencia humana en cuanto tal y ofende a la humanidad misma. El deber de tutelar tales derechos trasciende, pues, los confines geográficos y políticos dentro de los que son conculcados. Los crímenes contra la humanidad no pueden ser considerados asuntos internos de una nación. En ese sentido, la puesta en marcha de la institución de una Corte Penal que los juzgue es un paso muy importante. Tenemos que dar gracias a Dios que siga creciendo en la conciencia de los pueblos y las naciones la convicción de que los derechos humanos sean practicados universalmente e indivisiblemente y sobre todo sin fronteras. Por tanto, a partir del 1 de julio del año 2002, los graves crímenes internacionales cometidos por individuos nacionales o extranjeros en nuestra jurisdicción pueden ser juzgados por la Corte Penal Internacional. La primera obligación que asumió el Estado hondureño al ratificar el Estatuto de Roma es la de investigar, juzgar, sancionar a los responsables de ese tipo de crímenes y reparar a las víctimas. No obstante, cuando el Estado no cumple con esta obligación, la Corte Penal Internacional tiene competencia para juzgar dichos crímenes. En otras palabras, la Corte Penal Internacional no sustituye a la jurisdicción nacional, pues en virtud del principio de subsidiariedad, solo tendrá competencia para conocer de los crímenes cuando la jurisdicción nacional no cumpla con su deber de perseguir y castigar a los responsables de estos delitos. La Corte Penal Internacional ha sido para mi país un instrumento para combatir la impunidad y lograr el respeto y la efectividad de los derechos humanos. El Estatuto de Roma y los elementos de los crímenes distinguen los delitos ordinarios de los crímenes de lesa humanidad. En ese sentido, en el año 2010, la Fiscalía de la Corte Penal Internacional inició un examen preliminar sobre la situación de Honduras para determinar si existía una base razonable para abrir una investigación con respecto a supuestos crímenes internacionales cometidos después del golpe de Estado en junio del año 2009. Mi país, desafortunadamente, fue el primer país en este siglo en donde se dio un golpe de Estado, en donde se sacó a un presidente que fue electo mayoritariamente por el pueblo, por las Fuerzas Armadas de Honduras. Y a partir de una denuncia precisamente de parlamentarios del Congreso Nacional, se inició, digamos, después de 10 años que teníamos de afiliación a la Corte Penal Internacional, una investigación por parte de la Fiscalía. Esto fue muy importante para nosotros en Honduras. De acuerdo con el artículo 7 del Estatuto de Roma, los crímenes de lesa humanidad son todos aquellos actos inhumanos que se cometen como parte de un ataque generalizado o sistemático, que se dirigen contra una población civil y de conformidad con la política de un Estado o de una organización. Al año siguiente, en el año 2011, terminó la investigación de la Fiscalía de la Corte Penal Internacional y desafortunadamente la Fiscalía decidió cerrar el examen preliminar por considerar que a la luz del artículo 7, las graves violaciones a derechos humanos cometidas en Honduras no reunían los requisitos legales para considerar los crímenes de lesa humanidad y, por tanto, para que entren dentro de la competencia de la Corte Penal Internacional. No obstante, esa decisión de la Fiscalía de la Corte Penal Internacional provocó en el Congreso Nacional de la República que introdujésemos en un nuevo proyecto de Código Penal que sancionamos dos tipos penales importantes de lesa humanidad que los parlamentarios en una decisión mayoritaria, casi por unanimidad, decidimos tomar dos tipos penales que contiene el Estatuto de Roma e incluirnos en nuestro Código Penal. Y lo otro que nos pareció muy importante en el Parlamento hondureño fue que a partir de esa investigación que hizo la Fiscalía de la Corte Penal Internacional, las Fuerzas Armadas de Honduras, que son las que dieron el golpe de Estado a un presidente civil, tienen mucho temor a partir de eso de volver ni siquiera a insinuar a dar un golpe de Estado. No tuvimos un final feliz en el sentido de que nuestra denuncia prosperara, pero sí ha servido, como efectivamente lo hemos demostrado posteriormente, que las Fuerzas Armadas le tienen temor a la Corte Penal Internacional. Así que nosotros no nos equivocamos al habernos adherido al Estatuto y a la Corte Penal Internacional. Finalmente, nuestro Parlamento, este año, hubo un debate intenso, efectivamente, sobre la intervención que debía tener la Corte Penal Internacional en un conflicto en donde nuestro Parlamento ha actuado de manera casi unánime en solidaridad con nuestros hermanos palestinos y nuestros hermanos del Líbano, que son objeto de una agresión totalmente injusta por parte de otro Estado que dice defenderse. Y nosotros hemos criticado muchas veces el doble estándar que se tiene con respecto a los conflictos en que se puede intervenir por parte de la Corte Penal Internacional y otros organismos internacionales, e inclusive los pronunciamientos que los parlamentos que tenemos que hacer a la luz de la violación de grandes derechos y violaciones de los derechos humanos. Yo quisiera finalizar llamando a ustedes, a nosotros colegas, que debemos de dejar el doble estándar y solidarizarnos con una actuación grave que está pasando en este momento en el mundo. La agresión de un país contra una población indefensa totalmente. Nuestra solidaridad del Parlamento hondureño con el pueblo palestino y con el pueblo libanés. De verdad que lo condenamos. Muchas gracias.
Gracias. Thank you. We have had the case of Honduras. We are going to... We've had the case of Honduras. We are going to move to Pakistan, and we're going to get a presentation from Senator Azam, Nazeer, Tarar, who is a member of Parliament of Pakistan, and the Federal Minister for Law and Justice. Welcome.
Bismillahirrahmanirrahim. Honorable parliamentarians, distinguished guests, excellencies, ladies and gentlemen, and indeed the moderator. Good afternoon and assalamu alaikum. I am delighted to welcome you all in Islamabad at the 45th Annual Conference of Parliamentary Global Action Forum, PGA. On behalf of Government of Pakistan and the people of Pakistan, I would like to thank all for coming from different parts of the world to participate in this landmark event to testify common values and commitments we all carry within us for upholding sustainable principles of peace, stability, and respect for human rights. I would also like to applaud tremendous efforts made by the August organization over the past 4.5 decades. In continuous manner, PGA members around the world are playing an important role through strengthening the instruments of international criminal law, global warming, and development issues, including democracy and governance. Distinguished guests, members of parliament play a central role in national and global efforts to promote and protect human rights, democracy, and peace as democratically elected representatives, as well as leaders in their own communities. Since its founding in 1978, Parliamentarians for Global Action have made significant progress in areas of major global importance, such as disarmament and peace negotiations, measures for non-proliferation and mass destruction, illegal trade in small arms and light weapons, maritime protection, sexual orientation and gender identity, reproductive health as well, early and forced marriages, migration and development, reform of democracy and human rights. The present state of the world calls for our focus to the dangerous issues: war, economic inequality, climate change, and even democracy. This is the high time parliamentarians from around the globe should come forward to take such pertinent issues head on and influence domestic and international policies for addressing these. Looking at the Pakistan's context, these concerns are very important, where combating climate change along with political and social change is a well-known community challenge. For many years, we have lived in a situation dealing with the past and organizing development and peace in a difficult area. We strongly believe that the solution to problems that the world is currently facing is a global approach and cooperation, which is why we are happy to hold this meeting today. Having said that, I would like to highlight the challenges and factors that contribute to the variances in the implementation and adoption of reforming national laws in context to ICC. One of the key factor is the cultural and social context, like the laws reflect local values, norms, and historical experiences, and we have to actually bring those in conformity. Political systems and institutions are the second element. Different governance structures, political ideologies, and interest groups influence law reforms, and we have to deal with these. Then comes the economic conditions, of course, play a very pivotal and basic role. Economic development, resources, and priorities impact law reform adoptions. And then come the legal traditions and frameworks. Indeed, we hail from different legal backgrounds. The civil law and common law are the two examples. Besides, countries adopt reforms at different pace due to varying capacities and priorities. Some countries adopt comprehensive reforms, while others make incremental changes. Therefore, effective implementation and enforcement of reform laws vary across the countries. Pakistan's contribution to international peace and justice is one of the area I'll take a minute. The Pakistan has always stood for the values of peace, stability, and human freedom. We have participated in many UN peacekeeping operations and actively participated in various regional and global peace initiatives. We firmly believe in peace and peaceful solutions of the world disputes, including the issues of Palestine and Kashmir, which are facing serious violations of human rights. And when we talk about Gaza, the history will tell us that how painful this dispute is. Violation of human rights, and unfortunately, world is failing to effectively intervene for peaceful solution of the conflicts. In this context, yes, complementary principle has been violated. The domestic jurisdiction issues are always on the table, and states are undermined by international criminal, and these issues undermine international criminal court rather than building capacity of countries to control through their own local laws the issue of genocide and crime against humanity. And we have to think through, we have to learn lessons from history that unless and until we don't go for a global approach, we'll be failing in our duty as a nation, as a state, as member of this larger global community. We are committed to promoting human rights, social and economic development, and building resilience to climate change within our country and to stand with all global policies and action plans. The legislation passed by National Assembly and Senate of Pakistan is of great significance for the rights of women, minorities, and poor sections of societies. Moreover, we are not only victims but also advocates for positive actions. And I believe that the time would come when we would also be heading towards some positive actions for joining this club, the International Criminal Court. Worthy parliamentarians from global parliaments, on this day we all appreciate the great role we play as representatives of our people, not in our countries, but for global citizens, for this beautiful planet. We need to give voice to voiceless, help those who need it most, and fight for global justice. And this is one of the areas where we should raise our voice against the crime against humanity, the horrible crimes like genocide. The work we do in gatherings like this should benefit the people and produce results, work that will be remembered for years to come, work that would benefit the posterities. This agreement is more than just talk. It is a call to action. We must also use our unity and influence to support the rule of law, protecting human rights, and work to address issues such as extremism, inequality, genocide, and crime against humanity, the war crimes. At the end, I would like to express my sincere gratitude to all of you for coming together for this wonderful event. Your contribution will help build a world of peace, justice, and respect. I believe that it is not too late to engage in dialogue, conversation, and work together to create an era of justice, peace, and prosperity for all across the world. Pakistan is working with the rest of the world to achieve these goals, and we look forward to working with each and every one of you to realize our shared dreams. Thank you very much.
Thank you for the presentation. We'll move to Uganda, and we'll get a presentation from Honorable Fox Odoi-Oywelowo, Chairperson of the Human Rights Committee of the Parliament of Uganda. Welcome.
Thank you, Honorable Chair, for the invitation to speak. And thank you very much for pronouncing my name correctly. The Honorable Chairperson and I belong to the same ethnic grouping in East Africa. Thank you, honorable colleagues, for listening to me this afternoon. The Republic of Uganda is a state party to the ICC statute. The Republic of Uganda ratified the Rome Statute, and in 2010, the Republic of Uganda enacted the ICC Act, often cited as Act number 11 of 2010. The objects of the Act were to implement Uganda's obligations under the Rome Statute, number one. Number two, to make provisions for the punishment of the crimes of genocide, crimes against humanity, and war crimes. And number three, to enable Ugandan courts to try, convict, and sentence persons for the crimes I have stated. Worth noting that sections 7, 8, and 9 of the Act provide for the offenses of genocide, crimes against humanity, and war crimes, respectively. The punishments given under the law are the following: genocide, imprisonment for life or a lesser term, section 7.3. Crimes against humanity, imprisonment for life or a lesser term, section 8.3. War crimes, imprisonment for life or a lesser term. I make reference to this because I will make general comments in respect of that. Subsequently, the Republic of Uganda created a war crimes division at the High Court of Uganda. The Republic of Uganda was also one of the first countries to invite the prosecutor to investigate crimes under the ICC statute. The prosecutor investigated and subsequently indicted a number of Ugandans, notable among them Joseph Kony, who's still at large, Ongwen, who was successfully prosecuted and convicted. And I invite all of you to read the locus classicus of Ongwen. Thereafter, we stalled, and it's the excuses we continue giving for stalling that I will address you to this afternoon. Uganda did not ratify the subsequent proposed amendments to the ICC statute, despite the Parliament of Uganda passing resolutions to urge the government to do so. Now, when I talk about African politicians, only read it in the context of Ugandan politicians, because I don't want to offend my other friends in this room. African politicians are an interesting lot. We create excuses for everything, and we create excuses for dishonesty. What excuses have we come up with for not ratifying the subsequent amendments? Number one, if you speak to the powers that be in Uganda, they will tell you that there's a distinction between wars of aggression and wars of liberation. And there's a very thin line between wars of liberation and wars of aggression. What is the objective reality on the ground? As we speak now, Uganda has troops deployed in the Democratic Republic of Congo, in South Sudan, in North Sudan, in Somalia, in Central African Republic, and many other places. So if we sign up to the crimes of aggression, we may be the first ones to be prosecuted. So every time you raise this, they will tell you, but there's a difference. In Somalia, we are defending our Somali brothers. in the Democratic Republic of Congo, we are hunting down the Allied Democratic Forces. Are we involved in aggression? Probably yes, probably no. But we will always flag this as a dishonest defense, in my view. Number two, they will also argue that the sentences provided under the ICC statute are weaker than the sentences provided in our national laws. Genocide is mass murder. The sentence provided under the ICC statute is a maximum cap of life imprisonment. Murder in Uganda attracts the death penalty. So we still keep the death penalty in our statute books. But this defense is still dishonest because when we domesticated the ICC statute for genocide, we went for the maximum cap of life imprisonment. So why do we later in the day raise that defense in respect of aggression and other offenses? Number three, they will tell you, and I had this argument this afternoon, that the ICC only targets African leaders. And they will cite the case of Bashir, they will cite the case of Ruto, who is somebody's president now. They cite the case of Uhuru and several others. Again, the objective reality on the ground is this, that Africa's per capita contribution to wars and confusion in the world is much higher than anybody else's confusion. As we speak now, we have wars in Mali, in Somalia, in Nigeria, North Sudan, South Sudan, the Democratic Republic of Congo, Mozambique, and probably many other places. And definitely there are crimes being committed in all those areas. So if you take any action, they will tell you, but you are targeting only or mostly African leaders. Yes, it's because you provide the most confusion in the world, and therefore you should perhaps be targeted. They will also tell you that we should develop Africa's solutions to Africa's problems. Africa's solutions to Africa's problems. I'll make no further comment. Number five, they will tell you that the international community is migratory in their focus on international crimes committed, especially in Africa. So if you speak to the people in my government today, they will tell you there's ongoing war in North Sudan. The world has since shifted its focus. There has been war for a very long period of time in the Democratic Republic of Congo. I think we have normalized it. I no longer see it on the headlines. The war in South Sudan, Boko Haram in Nigeria. I don't even remember the last time I heard about Boko Haram, and I'm from the African continent. The focus now, and probably rightly so, is on Ukraine, is on Gaza, is on the situation in the Middle East. And I think we have also forgotten that there's war in Syria. When was the last time we sat down to discuss the confusion in Syria? Then there's the argument to withdraw or to remain in the ICC. And African politicians will always threaten to withdraw from the ICC when their comfort zone is threatened. when they prosecuted Uhuru Kenyatta and Ruto, the African Union sat and passed a resolution that we must withdraw from the ICC. And I kept on telling the people back home, we were the first ones, one of the very first ones to invite the ICC to investigate Kony and the confusion back home. At what point did we take the position that we must now withdraw? I am summing up, and in my summing up, I want to appeal to you, honorable colleagues, that they are irreducible minimum principles. And to me, these irreducible minimum principles can only be presented by asking you two questions. Question number one, crimes against humanity, genocide, and war crimes, are they so reprehensible as to call for our support of the ICC, as to be outlawed? The answer to any member of the PGA should be a definite yes. Should be an automatic yes. The answer should be in the affirmative. My second question, with all its imperfections, and I'm recognizing here that there's no human enterprise that is perfect, should we continue supporting the ICC? Again, the answer to all of us seated in this room should be a definite yes. We can talk about making it perfect, but the irreducible minimum principle should be that we must continue supporting the ICC. And lastly, you know, the administration of justice, more especially the administration of international justice, is a noble and thankless job. I invite my friends from the ICC to always remember that. You are doing a noble job. Nobody will ever applaud you, and don't ever expect any politician to stand at the side of the road and clap for you. I thank you.
Thank you very much for such a good presentation. Before I call our last speaker on this, I just wanted to say, because you mentioned Uhuru Kenyatta and Ruto, forgetting that maybe there are people who don't know who Uhuru Kenyatta and Ruto are. And I know because Kenya is often used as an example of why ICC is used as a prosecutor for Africa. In Kenya, it is Kenya that invited ICC. ICC did not invite itself to Kenya. When we had the post-election violence in Kenya, and we were asked through the mediation team to look for local solutions, and there were 6 names that were given in an envelope to a mediator, and who are that contained suspects, and they were supposed to be tried within the country. But we preferred to go to the ICC. So nobody invited us. We took ourselves there. And having taken ourselves there, we then turned around and said ICC is prosecuting us, as prosecuting Africans. So Kenyan case is actually a mixed bag, but I would consider it mainly positive in the sense that one of the 2 people who are prosecuted, of course, all the people who are prosecuted were released. However, 2 of the people who are prosecuted, one is the immediate former president. He was thereafter elected as president. The second person who was prosecuted is the current president. And so it speaks again to some level of fairness of ICC, because they went through the trial and they were heard, one of them as a sitting member, head of state. And they were both acquitted, and the other people were both acquitted. Of course, it also speaks to the issue of protection of victims, which also came up very strongly, and whether there's ability to protect. But then it also speaks to the issue of innocence until proven guilty. Everybody presumes that if you are taken to ICC, then you are definitely guilty. The courts are supposed to find you guilty. I thought I just wanted to clarify that, because after we hear our last speaker, then I'll open the door for debate. My brother from Uganda has raised some very interesting discussions, and I could see animated consultations even as he was speaking. And on that note, I'll invite our last speaker for this session, Honorable Margarita Stolbizer from Argentina. She's the founder and president of the political party Generation for a National Encounter, and is a former PGA president. Honorable Margarita will be speaking to us online or virtually. Welcome, Honorable Margarita.
Muchas gracias, estimada diputada Millie. Voy a hablar en español. Lamento mucho no poder estar con ustedes en Islamabad. Un problema de salud me ha impedido hacerlo a último momento. Quiero felicitar a PGA por la realización de este 45 encuentro anual y la 13 Asamblea Consultiva de Parlamentarios por la Corte Penal Internacional. Esto vuelve a testimoniar el fuerte compromiso de PGA con la defensa de los derechos humanos, el Estado de Derecho y la lucha contra la impunidad. Justamente la lucha contra la impunidad como el camino más directo para garantizar la paz y la seguridad internacional es el objetivo principal de este Estatuto de Roma firmado en 1998. El Estatuto de Roma crea un sistema jurídico penal que debe funcionar de manera armónica y que empieza estableciendo el deber principal, el deber primario de investigación de los crímenes más graves que afectan a la humanidad, estos crímenes internacionales, reconociendo al Estado como quien tiene el primer deber de juzgamiento. Esto a partir de establecer lo que se ha dado en llamar el principio de complementariedad, que establece entonces el funcionamiento de un sistema que empieza en las justicias nacionales. De ahí se va a derivar entonces el tema de nuestro panel, que es el deber de implementación de los estados, y que en nuestra región de América Latina tiene avances diferentes, digamos. Ya el preámbulo del Estatuto de Roma establece que la Corte Penal Internacional establecida en el Estatuto será complementaria de las jurisdicciones penales nacionales. Y en el artículo 1, que instituye la Corte Penal, dice que está facultada para ejercer su jurisdicción sobre personas respecto de los crímenes más graves de trascendencia internacional y tendrá carácter complementario de las jurisdicciones penales nacionales. Ese principio de complementariedad fortalece las soberanías nacionales y es el principio de protección de los derechos humanos. Eso es lo que establece entonces un sistema que pone obligaciones a los países que no se agotan con la ratificación. Si bien el objetivo de universalización y que es lo que daría más fuerza a esta Corte, que es que todos o más países ratificaran o se incorporaran a este sistema judicial, lo cierto es que no es suficiente con ratificar, sino que de ahí se derivan una cantidad de deberes que tienen los estados para garantizar efectivamente el funcionamiento de este sistema. El deber más importante que se reduce de la firma o la ratificación del Estatuto de Roma es el deber de implementación. La implementación no es otra cosa que llevar a nuestra legislación positiva las normas específicas que están en el Estatuto y que son las que van a permitir la actuación de este Tribunal Penal Internacional. En particular, la primera obligación de implementación recae sobre la implementación de las normas que tiene el estatuto y dentro de esas la tipificación de los crímenes. Incorporar en nuestras legislaciones nacionales la descripción de los crímenes internacionales que están en el Estatuto de Roma es la primera, digamos, obligación que tenemos o deber de implementación, siempre aclarando que todas estas cuestiones no son simplemente atribuciones que los estados tienen, sino que a partir de la ratificación se han convertido en deberes jurídicos de los estados que tienen que hacer esa, acomodar esa legislación nacional. Entonces, decíamos, lo primero es implementar las normas, tipificar los delitos, incorporar las normas procesales y también todo lo que hace a la jurisdicción y la competencia de los tribunales y de la Corte. A partir de la implementación de esta tipificación, devienen también otras obligaciones de implementar en la legislación nacional, como es la ratificación de las enmiendas de Kampala, los acuerdos de privilegios e inmunidades, los acuerdos de cooperación con la Corte y todas las acciones que también son deberes para los estados para fortalecer la Corte y preservar su integridad, ¿no? Contribuir a la designación o la nominación de candidaturas de jueces y demás. Insisto, porque se trata de un sistema jurídico penal que no sustituye la justicia de los países, sino que solamente va a actuar cuando la justicia nacional no puede o no quiere hacerlo. No es una instancia de apelación, no sustituye, al contrario. El ejercicio de la soberanía de los estados es lo que ha determinado que los estados suscriban su adhesión a este sistema jurídico penal internacional. Dentro de, a mí me gusta siempre hablar del rol de los parlamentarios, ¿no? Los parlamentarios tenemos un primer rol por haber sido electos en representación de nuestro pueblo, que es justamente eso, representar a un pueblo, y en la mayoría de nuestros casos en América Latina representamos poblaciones que han sufrido muchas violaciones a los derechos humanos, y entonces adherir a este Estatuto de Roma, implementar esas normas, participar de ese sistema de justicia penal universal es representar a los pueblos que realmente necesitan terminar con la impunidad, tal cual lo planteó mi colega Barrios de Honduras tempranamente, que es cómo en nuestros países esto nos sirve en realidad para prevenir y evitar cualquier tentación de sectores autoritarios que quieran interrumpir los gobiernos democráticos para violar los derechos humanos. Pensar en la lucha contra la impunidad es también incorporar los principios dentro de los deberes de implementación, dentro del rol de los parlamentarios. El primero es representar, el otro es incidir, por eso la importancia de hacerlo para que nuestros estados se comprometan en este sistema. El otro es legislar, porque estas cosas se hacen a través de las leyes. Y el otro es controlar, por supuesto, que se cumplan o que los ejecutivos cumplan. También tenemos la obligación de capacitar, de formar, de sensibilizar. Y en el tema de adaptar las leyes, decía, la implementación nos implica el deber de incorporar los principios de legalidad. No hay crimen sin ley, no hay pena sin ley, el principio de la responsabilidad penal individual, que son algunas de las cuestiones que tiene el estatuto y que debemos llevar a nuestra legislación, la responsabilidad de los jefes de Estado, o sea, eliminar cualquier sistema de inmunidad que puedan tener los funcionarios de más alto rango, la imprescriptibilidad de estos crímenes, la no posibilidad de indulto o amnistía respecto de estos crímenes más graves. La otra cuestión, como dije, es incorporar los crímenes, genocidio, lesa humanidad, crímenes de guerra y crímenes de agresión, La otra cuestión es el derecho a las víctimas. Si algo tiene el Estatuto de Roma es la consagración de los derechos de las víctimas en una amplitud muy, muy importante y destacable, como es reconocer a las víctimas. El primer derecho, que es el derecho a la justicia, a que se haga justicia, se esclarezca, se llegue a la verdad, se aplique un castigo. Pero además se incorporan también el derecho a participar en los procesos, a actuar, a tener información, el derecho a la asistencia, a la protección, a la indemnización, a la reparación, a la rehabilitación, la restitución y por sobre todas las cosas la satisfacción y no repetición. La aspiración más importante que tiene este estatuto es que esos crímenes no se repitan y de ahí la importancia de la aplicación de un castigo. Quiero hacer referencia brevemente a lo que son las normas procesales, porque los artículos 7 y 8 del Estatuto de Roma recogen por primera vez en un tratado de esas características los delitos de índole sexual, que están incorporados como aspectos de los crímenes más graves, que son violación, esclavitud sexual, prostitución forzada, embarazo forzado, esterilización forzada, violencia sexual. Y el Estatuto de Roma agrega normas especiales de procedimiento y prueba para las víctimas. Y es muy importante esto también dentro de nuestro deber de implementación. Esas tres normas son: no se requerirá la corroboración del testimonio de la víctima en los casos de violación. La segunda, el consentimiento de la víctima no podrá ser usado por la defensa como argumento. Y el tercero es que no se admitirán pruebas sobre la conducta sexual de la víctima. La otra cuestión a tener en cuenta es que siempre en la implementación y en la tipificación de los crímenes debemos tener en cuenta que el estatuto es un piso y no un techo. ¿Por qué razón? Porque a veces nuestros estados están comprometidos por acuerdos internacionales de derechos humanos que tienen estándares de protección más altos. El Estatuto de Roma, si bien tiene estándares de protección altos, no son los más altos porque en función de buscar los acuerdos y las firmas necesarias, se cedieron en algunos aspectos. Entonces, cuando nuestros estados tienen protecciones más altas, eso es lo que hace que se pueda satisfacer el compromiso de implementación con el estatuto. Para terminar, en mi país, Argentina, nosotros definimos la política de derechos humanos como una política de Estado. Por lo tanto, son las políticas que se sostienen a lo largo de los años y en todos los gobiernos, transversalmente. Tal vez porque somos un país que sufrió una cruel dictadura militar y la salida, la recuperación de la democracia se inició justamente con lo que llamamos un histórico juicio a las juntas militares que terminó con las condenas de aquellos que habían violado los derechos humanos y la sucesión de los juicios. A partir de ahí, nuestro país, en enero de 1999, firma el Estatuto de Roma del 98. En el año 2001 se dicta la ley 25390 de ratificación del estatuto. En el 2007 se dicta la ley de implementación, tipificando todos los crímenes que quedan incorporados en nuestro Código Penal. Ese mismo año se firma la ley de ratificación del Acuerdo de Privilegios e Inmunidades. Se ratifican posteriormente las enmiendas de Kampala. Y también en el año 2016 se firman los acuerdos de cooperación y se ratifican. Y Argentina es el primer país en firmar los 4 acuerdos de cooperación con la Corte: protección de testigos, ejecución de sentencias, libertad provisional y la puesta en libertad. Nuestro país tiene un fuerte compromiso con esto y entendemos además que el deber de implementación se cumple en la medida en que incorporamos todas estas cuestiones, no solamente el tema de la tipificación de los crímenes. En definitiva, el compromiso por una paz y una seguridad a nivel internacional dependen justamente de esta lucha contra la impunidad. Y eso a su vez depende de que podamos como Estado garantizar no solamente el funcionamiento de democracias electorales, sino democracias que aseguren la vigencia plena y total de todos los derechos humanos a todas las personas, el funcionamiento de una justicia eficaz e independiente y también el compromiso de trabajar por una justicia universal para que en ningún lugar del mundo se puedan violar los derechos humanos y que esto no sea castigado. Les agradezco mucho y les deseo una muy buena fin de jornada.
Muchas gracias, Deputy Margarita. Thank you very much. I'd hope to delegate honorable delegates that would redeem time, but unfortunately not. So I'll only open the door for 3, or the window for only 3. The first 3, I think I've seen Tanzania, I've seen here. Pardon?
Namibia.
Oh, sorry, that's Namibia, and then I'll have here. Is there anybody else? I think that's all. So you're good people. Thank you. Proceed.
Mr. Chair. Hello. Thank you, Chairperson. I have a question from my law minister. That whether our laws are tuned to co-op with the international laws, because you was talking about fusing both the laws, local laws with the international laws. Are our laws are in a position whereby the international laws can be tuned, flashed, and then can adopt all those international laws with the treaties also?
Thank you so much. I think it's the most crucial question which actually stands in the way of rectifying international treaties or international arrangements. Well, the law is something which can always be modified, enacted, synced with the obligations which you actually accept while rectifying a treaty. I'm sure there are many international law experts here and some of the students like me who know little about international law. Why international law or international instruments are being widely criticized is the hesitation on the part of the states to not surrender, but to forego their domestic jurisdiction in many ways. In order to build a peaceful world and in order to achieve maximum benefits from international treaties, be that it may the International Court of Justice or International Convention Against the Illicit Trafficking in Drugs, or elimination of discrimination or covenant for civil and political rights, there has to be will on the part of state that it should not be a cosmetic exercise. There has to be a will, and I think these are the forums where we can discuss these things. We, being the parliamentarians, can campaign for it, can raise our voices on the floor of the House of the respective parliament, that let this world be a place to live for all, and not only for mighty figures. And I'm glad that PGA has been campaigning for this for a very long time. ICC was also one of the not if the brainchild, but I mean PGA had worked very hard for this. Laws are always modified, tuned in to get maximum benefits from the arrangements you are going to make. If you agree to enter into a community like the International Court of Crimes, you have to bring in line your domestic laws, like the 3 basic areas. In every country, these offenses are considered as universally accepted crimes by one way or another. If you are signatory to International Declaration for Human Rights, yes, these are crimes already there. If you are signatory to civil and political rights, yes, these offenses are, and even otherwise, these are now the crimes which are universally accepted crimes. So there is no, I would say, hindrance, or there is no kind of the legal obstacle in rectifying the treaty. If there is a will, there are many ways to do it. Thank you.
Thank you, Namibia.
Yes. Yes, thank you very much. My name is Max Kashimune from Namibia, the Namibian National Assembly, member of the National Assembly. As Namibia, we do agree fundamentally that the ICC is an important instrument for the protection of human rights which are inherent, which are inalienable, and which are indivisible. So the ICC for us is a very important instrument. And I've listened to the interventions since morning and the various concerns surrounding the ICC. And one crucial topic keeps arising, and that is the trust in the institution. Now, when one listens comprehensively to these contributions, you realize that the trust deficit in the judicial institution known as the ICC stems primarily from a belief that there are so-called superpowers that have not acceded to the Rome Statute in the first place. So we are perhaps of the thinking that as the PGA, and perhaps this is a philosophical question and thought to the panel, as a PGA, we should be questioning one thing. If you, as a nation, are part of the United Nations, and you have conformed to the values, the aspirations of the United Nations, to which the International Criminal Court falls under, then what is your concern really about acceding to the Rome Statute? We should start questioning that. We should go further and question whether is it not about time for the sanity and preservation of these institutions before other countries also say that, man, but we see this country is not joining. Why should we also join? And why should we keep joining such institutions? Is it not about time that institutions and organizations such as the PGA start posturing to say that the United Nations must in fact start compelling nations that will not join an institution, a very important institution, which brings international criminals of genocide and war crimes to account, such as the ICC, to start compelling nations such as the United States and so forth to accede to the ICC. Because if you know what the values of the United Nations are, why are you afraid to join an organization that is under the United Nations and that postures the values of the United Nations? Because we understand issues of you are afraid that your domestic laws will be violated and so forth. But is that really a concern? Is that the main concern? We should start questioning ourselves. And we should start also agitating as the PGA to start compelling and start agitating the United Nations to say that a nation must actually be compelled to join the ICC because other nations are joining. By now, why not you? What is the real reason why you are not joining a genuine institution such as the ICC? Thank you very much.
Thank you. I think that's a comment, but which also, it's not a question, unless one person from the panel really wants to speak to it. It's a comment. And maybe I could just say that I could just try and say in one answer that once upon a time before I joined Parliament, I used to work in the children's sector. And if there was an international treaty that was widely ratified all over the world because it's non-controversial, was the Convention on the Rights of the Child. And there were only 2 countries that hadn't ratified it then. I don't know about the status now. That time, Somalia had not ratified it because it did not have a government. And the United States, because it had the government. I hope that answers to you.
And
yeah,
with the kind permission of Chair, if I am allowed, as you rightly talked about the trust deficit or why they failed, These are, as my friend said, from here and there, and I think everyone should be on the unison, that trust deficit comes from double standards. I mean, there are two war zones right now in the world, in this region. The response from mighty states, the states who matter in the world politics, response for Gaza and Ukraine is the answer.
Very last one. I can see now people are carrying hands, but I don't think we have. Maybe I'll just give you this last one before I give my brother here to respond. Just those two, because we've completely run out of time. I'm sorry. We started a bit late.
Buenas tardes. Mi pregunta es para el señor de Honduras. In English, I'll do it in English so that everybody can actually get this. How daunting of a task was to bring the national laws of Honduras in conformity with the provisions of the Rome Statute when you had actually first acceded to it? So could you perhaps answer that, because this was a long time ago, and then you obviously had to brush up your national laws or bring them in conformity with the provisions of the Rome Statute. Gracias.
Ha sido un proceso porque cuando nos afiliamos al estatuto, en realidad había otro gobierno. Ha sido un desafío para el actual gobierno de la primera mujer presidente en Honduras, digamos, primero internamente en el Congreso, donde nosotros no somos mayoría, es decir, el partido que representa a la presidenta no es mayoría en el Congreso, la oposición sí lo es, pero nosotros hemos adoptado, y tal como decía nuestra colega de Argentina, algunos compromisos del estatuto. Número uno, hemos incorporado en un nuevo código penal que nosotros hemos hecho, precisamente 3 tipos penales que habíamos firmado en el estatuto. Y lo otro, y lo que más me parece, digamos, más representativo de lo que hemos cogido del estatuto es la reparación de las víctimas. Aún cuando la Corte Penal no satisfizo el hecho que se enjuiciara a los perpetradores del golpe, nosotros sí hemos reparado a las víctimas. Digamos, filosóficamente hemos tomado ese valor de reparar a las víctimas producto del golpe de Estado.
Thank you, Honorable Odoi. Just 1 minute.
In 1 minute, my brother from Namibia, I think the trust deficit you are talking about is superficial. Put another way, the trust deficit is a creature of the political class, and I will illustrate in just half a minute. If you go to northern Uganda and you ask the victims of the Konyi War, they will tell you the ICC prosecuted Ongwen, the ICC is in the process of compensating them. The ICC is the best international instrument they have ever interfaced with. If you ask the members of parliament, they will tell you something completely different. I thank you.
Thank you. I think that's a good point. That's a good point to close. And can we please give a general applause to the panelists for an excellent show? And of course to me for being a good moderator.